Most of you have heard the term no-fault divorce, and indeed Florida is a no-fault divorce state. But what no-fault actually means is frequently misunderstood by people, so very briefly let me explain that to you. When I first began practicing law, in order to get a divorce, you had to stand up before a court and show that you had grounds. Somebody was mentally cruel, somebody was physically abusive, someone had abandoned you. No longer in Florida do you have to have any grounds whatsoever in order to ask the court to dissolve your marriage. You can simply stand up and say, I want to dissolve my marriage. I want a divorce. You don't have to give any reason. You don't have to explain any fault. Hence the term no-fault divorce. Now that applies only to the actual divorce itself, the actual dissolution of the marriage. Because sometimes, depending upon the facts of the case, fault can have a major impact on the division of assets or alimony. And while that's for another topic, it is important to understand that Florida does follow the no-fault divorce rule, but that only applies to getting the divorce itself. Don't fail to tell your lawyer about any fault, that be it financial or extramarital, that might apply in your case, because it can very well have an impact on the money you get and the assets you keep.